done previously. We've taken some witnesses out of order. I've permitted the parties to take, or Mr. Hanners to take another witness out of order. And so just to let you know, Sheriff Norris still has some further questioning by the parties. He will return for that purpose. Mr. Hanners.
Defense would call John Trouette.
Sir, you've been called as a witness and you've kind of seen how this works. You can make your way around the table. Please, Madam Clerk, raise your right hand and be sworn, please.
Solemnly swear the testimony you're about to offer in this case is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And sir, please have a seat here at the witness stand if you're so comfortable. Mr. Hanners, you may inquire when you're ready.
Thank you, ma'am. Paul, introduce yourself to the jury and spell your last name for the record.
Paul John Trouette III. Trouette, Trouette.
Paul. What do you do for a living?
I'm a security contractor, and I have been for about 15 years, 15, 16 years. All over the Pacific Northwest, California, operating multiple different missions and accomplished organized security system.
And how did you come into contact with the KCRCC?
Oh, that was about a year ago, maybe a little bit longer than that, just through political affiliations and like-mindedness. We just met within the community at different events. So,
And did that relationship lead to a conversation as it pertained to the town hall event for February 22nd?
yeah, so over the course of the last year and a half, they've become aware of, what I do for a living, and I suggested that they could develop a stronger security mechanism for some of these politically charged events and other events. So I've been kind of just assisting them in developing some of those concepts, and then it evolved into this, into my involvement with the town hall.
And starting out, the initial intent for you to provide security at the town hall, how did you understand it?
I was told about 3 days, maybe 4 days before the event that event at town hall was going to take place. I've been involved in lots of different relationships in town business and churches and different things. So one of my concerns is that the mechanism for security gets established sufficient with threat assessments that are occurring, in our communities lately. So I suggested to them when they approached me about, security. It was Luke Summer that approached me about it initially, maybe 2-3 days before the event. And so we had very little time to secure everything. And so I just, I had talked to them about how I would proceed with doing that advance and that contract for that particular event, and how I would basically run that event.
Now, was it ever contemplated that your company would be hired or paid to do security?
I think initially we talked about that, but it just wasn't going to be achieved. We just didn't have the time to do that. I believe that on Friday, I think Officer Romero talked to me about trying to get him a contract by 1 o'clock. That just wasn't going to be achievable because the chairperson was in flight or on an airplane, so it just didn't look like it was in the cards.
So once it was determined that you were not going to be hired, how was it decided to proceed?
We were going to, first I agreed to go to the school and then provide kind of an assessment of the facility. And so I did an advance myself there with a couple of other individuals who were responsible for the committee. So it was my understanding that I was going to go there and provide them with some sort of guidance to how we would, give oversight to that event while it was going to occur. So that's initially was how we officially got started.
And again, this wasn't for compensation, correct?
No, I completely volunteered that, and I donated the entire time.
And okay, so let's fast forward to the day of. It's been testified previously that you
So we arrived there at approximately 11:30, and I briefed my guys on, we were gonna go in and just kind of make contact with the event coordinators and just kind of, roll into that, and we would go into roles and responsibilities later. So I met with Sheriff Norris just prior to the event starting, and we had talked about and discussed, I made it known my presence was in there, let him know how many individuals I had available to him. And so we talked about potential events, and then it was, at that time, he had shown me a picture of a person of interest regarding this potential mass casualty event. And he had asked me if we could assist him with the surveillance of the parking lot to make sure the white Equinox with the last three of the plate and the color of that. And so we assisted him at his request to go out and look at that parking lot.
And moving forward, did you have any other communication with the sheriff?
We communicated all day. I mean, we had communication and what I would consider collaboration virtually all day. Yeah.
And moving to the first individual that was removed, being Vince Stallings, there was previous testimony that the sheriff had commanded Vin to leave, and we watched that video of that moment in time on the ramp being in the auditorium. Do you recall that moment?
It actually began before that. He was making, Mr. Stallings was making a remark.
Objection, hearsay.
Not hearsay. Giving intent or not the statements made.
Sustained.
So in,
It was sustained.
oh, gotcha.
So, Sheriff Norris testified that you had previously communicated to him or with him regarding Vince Stallings, correct?
Correct.
Okay.
Yeah.
And at the time that the sheriff ordered Vince Stallings out of the auditorium, where were you?
I was down the ramp and inside the auditorium. As he was coming down, I was behind the pillar. You can't see me on that particular video because it's too far away.
And we watched the video yesterday of you and another security member walking Vince Stallings out through the hallway, correct?
Correct.
So, did anything happen or any interaction between you and the sheriff between the time that he asked Vince Stallings to leave when we see you guys walking through the hallway?
Well, when Sheriff Norris and I came into the building, I was ahead of him. And when he came in, Mr. Stallings had made a gesture and yelled a profanity. And then that was when Sheriff Norris was already aware of Mr. Stallings. And he had directed himself to Mr. Stallings. And then he went down the ramp, back up the ramp, and then ordered him to leave. And then at that point, when Mr. Stallings, when Sheriff Norris was coming, I think it was Sheriff Norris first, or I think it was when Ben was leaving, he pointed and addressed myself that we should, follow him out, so.
And then, after you followed Vince Stallings out, you returned, and what was the general mood inside the auditorium at that time?
It was starting to escalate, I wouldn't say, demonstratively, but it was beginning to escalate.
And when Sheriff Norris goes up and addresses Teresa Warrenpool, where were you at?
I believe I was still in the back of the auditorium.
Now, we've got plenty of testimony and video of what all took place in that scenario. Describe the time, the moment when Sheriff Norris grabs Gregory Johnson.
Yeah, so at that point, what was going on was an interaction of what I would consider, in this situation, we had quite a bit of chaos going on. And so there was a lot of exchange about interfering with his, with what I would consider an incident, a scene that was going on with Ms. Moorhall. So it was natural for the sheriff to try to clear that area because you have escalation, you have threats, you have potential.
This is again speculation of why the sheriff did it.
So the reason that was going on was because there was simultaneous events going on at the same time. It was not just one event. We now had Ms. Barnwell who was being dealt with and ordered to be removed, and then we had a secondary situation that was going on with Mr. Johnson. So there was all this, people were interfering and interacting with this incident that was going on, and it was necessary that those steps had to be taken to get control over that situation. So that's why Sheriff, he basically removed himself from the bar vault, seeing that my guys were addressing that, and then he addressed Mr. Johnson.
And you started aiding the sheriff with Mr. Johnson, and you assist him in guiding him out of the auditorium, is that correct? Now, that communication with Sheriff Norris heard audio. What was going on with that communication?
Well, as far as the Johnson removal,
Yes.
so it was exigent circumstances, and I don't think that's been been mentioned here. In exigency.
Objection, Judge, the gun is not giving. Your opinion currently, foundation.
Without going into your opinion on what the situation was at that moment.
It was clearly out of hand at that point. There was a lot of fog of war going on there, a lot of chaos. And so I felt that at that moment, for officer safety, that I assisted him. Yeah.
And then you guys walk Gregory Johnson out in the hallway.
Yeah.
You've seen that on video. And then the sheriff's leaving. What did he say?
So in the hallway?
Yeah.
He wanted that hallway clear. Yeah.
Objection, hearsay. Motion and move to strike.
Back on the listener.
Well, we've not heard that communication happen, it was just an assertion. The objection was sustained, the jury is asked to disregard that last answer.
In the hallway, did you have communications with the sheriff?
I did.
After those communications, what did you,
Are you talking about coming through the hallway with Mr. Johnson?
the communications that you had with the sheriff leaving you with Mr. Johnson?
Yeah.
What did you do after that conversation?
So you're talking about the conversation at the wall?
No.
Okay.
You and the sheriff got Greg Johnson at the wall, right?
Mhm.
The sheriff leaves, starts walking away.
Yeah.
Turns back, and he makes statements, correct?
Yeah.
Okay. What did you do after hearing those statements?
I stayed with the subject, Greg Johnson, and then affected that detainment by Norris's command.
Okay.
And so I just continued to keep that incident under control.
And at some point, you go back into the auditorium, is that correct?
Correct.
And what was the reason?
There was the element of, it was escalating dynamically. It was very dynamic and very fluid. A lot of different people were getting involved within that space where we considered to be, needed to be controlled and contained because of the danger. We did take some firearms off some people in the auditorium, so we have no idea who we're dealing with in there. And so it was my experience and training that we had to create a safe perimeter and then remove that possibility.
You were concerned that the situation was getting bad, so you went back in.
Correct.
Objection.
Back in the auditorium. What happened?
I attempted to assist the removal of Ms. Marple, and that was going very difficult because of her going limp, which is a direct action tactic to.
Objections.
Just what you did.
Okay. I just assisted to help remove so that we could keep Ms. Moore reasonably safe, you know, and also to, you know, assist in that so that we didn't need to use any unnecessary force.
And eventually, you guys get Ms. Marple out into the hallway, correct?
Yeah, I actually assisted for a small amount of time there, and then other things were happening, and I had to actually leave that area.
And during all this going on, did you have any further communication with the sheriff?
At the point of, not until I got into the hallway.
Okay. And
But it was evident that we had a fluid situation from the time it began. And in my estimation, there was never a time where I wasn't being requested from sheriff. There was never a time where I felt like it had to be broken or you know, some kind of a delineation.
so you understood the sheriff's request
I
to
did.
be cumulative
Cumulative,
for until,
until the situation was, you know, contained, yeah.
and then, now at some point you go back out in the hallway, and Grace is on the ground. What was your mindset? What was your thought process?
My mindset was to make sure there was no additional violence or anything like that that was gonna escalate in that hallway, because it's clear that she had, that situation in that area was attracting many people that were not, or should not have been allowed to be in that area, because there's several things going on. We have a mass casualty potential event, and this is escalating, and there's just multiple facets of things that are going on. And I was just trying to clear that area, make sure it was contained.
Okay. And that's when you had an interaction with Sarah, correct?
When I was at the wall with Mr. Johnson, I went back to manage that situation, make sure everything was going fine there. That's when Ms. Norpaul and the other individual, Russ Dunn and Chris Berg, spilled out into the hallway. And so as I look back from at the wall, I could tell that they might need assistance. So at that point, Jesse Jones took over the detainment of Mr., which I conferred on him at, you know, per Sheriff Norris's request and command. So what I did was I moved back towards, because I could see the hallway was starting to fill up with people who were interfering with our you know, removal of Ms. Marple. So I became concerned about that.
And that's when you had contact with Sarah, correct?
Correct.
Okay. And in the video that we watched yesterday, I believe it was, describe what was going on.
Okay, so in the hallway, Ms. Marple was, you know, was resisting, and she was not complying with our.
Specifically to Sarah.
Okay, so there were several people, there were several females and males that were congregating around the direct area that we were trying to clear. So talking with Norris earlier before, that hallway was very dynamic, and we needed to have that clear because of the amount of people that were gathering around us. Keeping in mind that, so I addressed Sarah very matter-of-factly, said you need to leave. I pointed my finger clearly, my hand went this way, you need to go this way immediately, you need to leave now, please. And
what was your interpretation of how she reacted to that?
well, she put her purse around her neck, which indicated to me that there was going to possibly be some resistance.
And that's when you contacted her. And
That's when I did what we call a soft escort. We tried to do a soft escort where usually you could go by the wrist or by the elbow, but I chose to just put my hand on the back and motion this way, and it became apparent she wasn't going to do that. And when I told her to leave, she said, I'm not going anywhere.
now, when Ms. Forsgren testified, you made a comment that you grabbed her breasts. Do you think that happened?
That's not even possible. I was behind her.
And in the video, we see you push her towards the exit, and then you stop it.
Yeah. So I tried to encourage her to leave. She wasn't leaving, she was resisting, so it became apparent that the area where Mr. Cornwall was getting more dynamic. There was more people coming near that, and that's just a recipe for, disaster. So I just tried to reestablish that control over there and try to get into that scene and clear the room.
With Ms. Warren.
Yep, yes.
Paul, are you familiar with Idaho's code for citizens arrest?
Yes.
Did you feel at the time that, for any reason, I'm not asking you to say the reasons, for any reason, that Ms. Warren was under arrest?
Yeah.
Objection, only question, under arrest at who?
Sustained.
Paul, did you believe that Sheriff Norris had placed Ms. Warren under arrest?
Effectively, I would say yes.
And what about Greg Johnson?
Yes. Detained, I would say detained.
And in fact, to your knowledge, were either of those individuals taken to jail?
No. One of them was charged with that.
Objection. Strike irrelevant, and so violation of personal travel.
Sustained, stricken, the jury will be directed to disregard to last trial.
I have no answer.
Cross-examination?
Paul, how long have you been owner of Clear Asset Management?
Since 2012.
Did you start it?
I did.
And how many employees did you have with Clear Asset Management on February 22nd, 2025?
How many employees did I have? I had 4.
And so the individuals shown that have been depicted in various videos throughout this trial, those were your employees at that time.
It was voluntary.
And you're here when there was testimony regarding the conversation you had with Chief Haley during the course of this investigation, correct?
Say that again?
You were present here in court
Yes, yes.
when there was testimony about that conversation.
Correct.
And you recall that the testimony was during that conversation, you told Chief Haley that you had the records of your employees with you when he referenced that he needed you to provide those.
Yeah, I was-
Sorry,
Hold on,
No,
hold
I'm sorry.
on, hold on, really important to let Mr. Hunter finish the
Yeah, I'm
question
sorry.
before you answer.
So the question was, during that conversation, testimony was that Haley had requested that you provide him with the records, the employment records for the employees that you had at the time of the town hall event, on February 22nd, 2025. And that was pursuant to a particular portion of Coeur d'Alene City Code 5.32.080. Correct?
Yes.
And you agree that that provision of Coeur d'Alene City Code with regard to security agents and agencies requires that upon request, summarizing, it's contained within State's Exhibit 9, but that upon request, you provide those employment records. You agree with that, right?
I recall that, yes, that code.
Hold on 1 second, is there an objection?
I'll withdraw my objection.
Oh, the answer will stand.
And you agree that it was testified that an entity or firm acting apparently in your direction advised that there was no employment records.
That was, yes, so when I had told Mr. Haley that I was gonna research and get in those records, in the meantime, I consulted with my attorney, and I believe I sent Mr. Haley a letter. You can refer to that as the reason those records were not given to Mr. Haley. You can refer to that.
Now, despite your understanding, which you agreed with here, that Coeur d'Alene City Code requires a provision of those records upon request.
Wrong code checks, getting into, seems to be attorney-client privilege, as the witness just stated, he spoke to his attorney on how to deal with that issue.
This question doesn't touch on attorney-client privilege overruled. You might have to re-ask your question, Mr. Martin.
Yeah.
And so your testimony here is that not asking for any contents of that discussion, why that conclusion was reached, but that you, after telling Chief Haley, based on your understanding, the requirements of Coeur d'Alene City Code, as reflected in state's exhibit 9. If you'd like, I can provide that for you, just so you can make sure that you.
No, I think I'm okay with that, yeah.
You initially agreed to provide that to him, but subsequently, through this firm, declined.
So my understanding, recollection of my attorney said at the time that he requested those documents, I didn't have any employees employed in Coeur d'Alene because of the revocation of my license, and those were not necessary. And I believe that was the body of the letter from my attorney, and so you'll have to refer to that.
But that's, you're sitting here, that wasn't what Chief Haley testified to, was it? He testified to the request for records of your employees that you acknowledged to the jury you had at the time
Yes.
for this town hall event. And you acknowledged that those were your employees.
Mm-hmm.
But then this firm, by your testimony, sent a letter saying no employee records at this time. It's not a letter saying.
It was the time that he requested that, and I had conferred with my attorney, and that was the answer that he had instructed me to give. And he gave a official letter to Mr. Haley, and I believe that Mr. Haley has that letter, and that would be my answer to that, would be based on that.
Do you agree that the names of those employees and their identities that have been testified to during the course of this trial, that those were accurate?
Identities of all the gentlemen that were.
Employees at the time?
Yes.
And so the owner of the business would you agree with me that the owner is the owner of this business? It's your obligation to oversee your employees,
Yes.
supervise them.
At times.
Would you agree that it's also your obligation to properly train them?
Yes.
Would you agree that it's also your obligation to ensure that they're outfitting while in the course of the employment?
Outfitting, what do you mean by that? I'm sorry.
No, you're okay. I pause there, so I understand that. The outfitting, in terms of the uniform, that it's compliant with what's required by Coeur d'Alene City Code, correct?
Yeah.
And you would dispute that Coeur d'Alene City Code quite clearly says that if you're going to act as a security agent, that it's required that you wear a uniform that clearly marks work security in a certain size on the front and on the back, would you not?
In certain applications, I would agree with that, yes.
If I could approach witness with stand exhibit 9.
Okay.
do have a couple of documents. I'm going to ask first about States Exhibit 9. So I'm handing you, Mr. Trouette, States Exhibits 8, 9, and 10. So starting with States Exhibit 9.
So 9 is the middle one?
No, that's the top one. I think that's the one. Please don't.
The advance?
No, the Port Orleans City Code.
Okay.
Certified copy.
Let's see, okay, gotcha.
And so I'm going to give you a chance, the specific code section I'd like you to review. Take a few moments if you need. 5.32.050. Go ahead and do that for a moment. I want to ask you a question.
Okay, I got it. Badge and uniforms.
So I want to ask you just what the first sentence of States Exhibit 9 says. See if you read it. It says this on your copy. It says, uniforms worn by security agents must be clearly marked.
Judge, I'm going to object. The exhibit has been admitted, and the witness is not qualified to make any determinations or conclusions of law based on the city portions.
I think this has been admitted.
It has, and the question that I'm about to ask, or was able to get to, was it's made a positive assertion that the uniform code applies only in certain circumstances. I'm inquiring about that.
I'm going to overrule the objection. I think this exhibit has previously been admitted, and the witness can be asked about it.
And so there's that first line of things. Uniforms worn by security must be clearly marked with the word security in letters no less than 1 inch tall on the front of the uniform, and no less than 4 inches tall on the back of the uniform. Do you agree that that's what it states?
That's what it states.
And if anywhere in that first sentence of that provision, does it state any exceptions or that it only applies in certain circumstances?
No, it does not, but I have a back story with that with regard to.
I'm not asking for a backstory, I'm asking for what the actual language of the
That
code
language,
says.
that's very good language. Yeah.
Thank you. So, in this instance, you agree that the evidence quite clearly depicts that you did not, in fact, have either yourself or any of your employees wearing a shirt that said security on the front or the back that was clearly visible by anybody in that auditorium.
That's correct.
You'd also agree that as the owner of the business, it's your obligation to ensure for yourself and for your employees that they're complying with any other regulations of the Port Orleans City Code applying to security agencies in order to act on behalf of a third party. Would you not? Would you agree with that?
Partially.
Well, let me ask you some questions and we'll see if we can parse out where the partially work. So one of the charges in this case is allegation that now your employees had a copy of contract providing their authority on behalf of the third party that they were working for, that they're working on behalf of. You understand that?
I understand the language, yes.
And that comes directly from Port Orleans City Code 5.32.060, which is contained within States Exhibit 9, correct?
Correct.
And so, I think you said partially, but I'm wondering, since the relevant portion upon which this charge is based says as follows. So, security agent working on behalf of a third party shall have in his or her possession at all times while working as a security agent a copy of the contract providing their authority on behalf of the third party. Do you agree that that's what it
That's what it said.
And so, during this event, you agree that it's self-evident at this point that you or any of your employees had a copy of an executed contract
Well,
to act on behalf of the third party.
yeah, we weren't working on behalf or conducting business. That's not.
Now, I want to ask you some questions about that. You offered your services to the KCRCC through Lear Asset Management, not through Paul J. Trouette, correct?
Correct.
each individual that was depicted as acting as a security agent on all the videos that this jury has been shown, they were not acting in their individual capacities as Russell Doon, as Jesse Jones, as Alexander Trouette, as Christopher Burke, correct? They were acting at your direction and at your supervision as employees of Lear Asset Management, correct?
Correct.
And so it was Lear Asset Management that was providing the security services at this event, wasn't
That's
it?
correct.
And just to confirm that the contract, the unsigned contract that you have before you states Exhibit 8, I believe, that's the same contract that you testified to on direct that tried to put together an email, but it never received a response. There's never an extension of that agreement.
That's my understanding.
In the security events, if I can move to that for a moment, there's State's Exhibit 10. There's mention there of, just to make sure that I'm being accurate what's actually contained in the security events here. Page 4, you agree that under roles and responsibilities, it says no disruptive individual.
Say it again, sir?
It's page 4,
Yes.
roles and responsibilities, second bullet point, it says no disruptive.
Second bullet point? Yes, note any weapons.
Sure. For any suspicious behavior allowed to move disruptive events and persons will respond. And you're noting that, right? And in this document itself, your own document that you've created ahead of this event, it also says that you warn those who are disrupting the meeting to cease, or they will be removed, and I believe it's going to insert this as a typo, they will be removed for the direction of the chair. Would you agree that's a typo?
I would.
Okay. At the direction of the chair? By the direction of the chair?
At, I would say at the direction. At or by, I would consider both of those
I would agree.
logically.
I would agree with that. Well, your testimony here today was that it did not indicate at any point that you were directed by the chair to remove anybody. You agree?
To remove anybody, I didn't take that action. I followed the action of the sheriff.
Just to clarify, it doesn't say anywhere in here that, at the direction of the chair or the sheriff. Does it qualify that way?
I'm assuming that if I'm with if I have a client relationship and we have the roles and responsibilities and we have the contract language which enumerates what's expected of me and what I expect of them, that's all laid out in the contract or the agreement or the direction or the advance. That was interrupted by the direct action of the sheriff that day. We were observing and reporting, and go ahead.
Well, I was going to say, I just wanted to talk a little bit about the assumptions, because I think that brings me to another point I think is worth discussing at this juncture. You testified a lot to the fact that you were assuming a lot of things when it came to what the sheriff wanted, correct?
I just took what our communication was. There was no assumption.
In fact,
Follow your line of thought right now. So,
I'll try to clarify. So,
Okay.
in fact, your testimony was with Kurt Benstock. Testified that you saw the sheriff pointing at you, or pointing at him, and then pointing.
Yeah.
That's your testimony.
Yes. My recollection, and it's on video.
Right. And you agree, no testimony by any party that there was a clear verbal articulation of anything at that point?
There was an eye contact, and I saw him point.
Sure. And so,
As we followed Mr. Scully's.
based upon that, you agree that you're assuming what he's meaning by that. He's pointing at you, and I think it's reasonable, not disputing, it's reasonable to assume. Meaning to point to you is to say, hey, you.
Well, we were involved in an incident, it was fluid and it was happening, and so we were communicating, whether it was gesture or verbal, it was acknowledged that we needed to be involved.
This was a cooperative, bilateral relationship. Would you say that?
I would just leave that what I said.
But he didn't clarify that that's what he wanted. He pointed to Ben, he pointed to you, and you understood that or assumed that meant follow him.
I didn't assume that. That was what was inferred by his direct,
Inference, I think, is a reasonable
Okay.
synonym for that. But just to be clear, he did not state directly to you, Paul, I'm hereby commanding you to follow Ben Stallings out, or this gentleman.
It was clear that he wanted me to follow Mr. Stallings out.
But
By
you-
his gestures and by his, well, a gesture would be what I would consider an interactive gesture towards my involvement directed by him.
But just to be clear, you agree that he didn't say any of those words?
I can't recall. I mean, I don't recall. I heard it was very loud in there, and as you may know, there's things that don't get captured, but it's very evident that it was captured on that video that he directed us to follow Mr. Stallings out. That's my
And,
interpretation.
I'll do that for the jury when they review it, maybe if they look at the video might pop up hand gestures, but you agree that there's no evidence before the jury right now that we would support that there's a verbal statement by the sheriff to you with regard to Mr. Stallings.
I would agree that there was communication that happened there that was demonstrative and that was absolutely clear,
Based on your understanding.
based on what the video shows.
And so, again, on the subject. Follow that out. You agree that none of the video, none of the testimony, none of the evidence has been admitted, none of your own testimony indicated that the sheriff clearly ordered you, commanded you, directed you, required you to make Mr. Stallings leave the building, correct?
Say that again?
Nothing in evidence right now, and not even your own testimony, would indicate that the sheriff commanded you to remove Ben Stallings from the building, correct?
I totally disagree with that.
Not based on that finger pointing.
Based on that video and videos that I've seen, I'm absolutely convinced that that's what happened.
And he never commanded you, directed you, instructed, required you to aid him in the execution of the duty that involved removing Ben Stallings from that.
I think the code's very clear.
Hold on, it's really important that you not interrupt
I'm
Mr.
sorry.
Kelly, just until he's done answering, asking you the question,
My
and
apologies.
give you, no, it's okay, just give you the opportunity to respond, so that it's really hard for back to take notes if everyone's talking about each other.
Okay.
And so, Mr. Hunter, I'm gonna have you re-ask the question.
Judge, I should just, I'll move on.
Okay.
Go again, I know this wasn't signed and executed. But I'll just move on to that. Let's talk about some of these other aspects of the assumption. You mentioned a conversation you had with the sheriff with regard to aiding him or helping him with some bomb threats. He did, the judge testified he requested, and actually I made a counsel against you. Something kind of observed for that purpose, would that be accurate? Would that be called a mass casualty event?
Yeah, I got that term off one of the reports, but It was essentially a threatening event that was fluid, and it was being investigated. The person of interest was alleged to be still, free and had not been apprehended for whatever reason.
And the concern was what might actually happen in the parking lot, right?
The concern was about the entire event. Yeah, I mean, inside, outside. Oftentimes, these events don't have any weapons checks. They don't conduct any screening or anything like that, so we don't know who has what. It's obvious we took some firearms of individuals in that building, and we don't know if anybody else could have a firearm.
And you agree, as Sheriff Norris actually acknowledged too, that occurred after, basically, all the events that form the basis for this case, correct?
Objection states the evidence of Sheriff Norris' testimony.
That was after.
No, that was during, we had removed weapons before that, before the warrant call went out.
So
we had
discovered
discovered weapons.
Discovered during the chaos, if you will, of that event, that some.
Actually, one of them was.
And I apologize, I hadn't finished my
I'm
question.
sorry.
It was discovered, I guess, as a result of the chaos of that event, that some individuals present in the auditorium had firearms, and you agree they weren't supposed to.
Yes, I agree. However, okay, sorry.
Trying to move along here, we've got precious time, so we're trying to be expeditious here. I've got a few more questions for you. I want to talk about some assumptions with Gregory Johnson. So the testimony was that Sheriff was having an interaction with Mr. Johnson. You saw him start to push him out of the auditorium, and you just joined, right?
There was a point that I was witnessing.
When was your testimony is previously, and I'm not trying to I guess, what that necessarily, but I just want to clarify that he did not say, previously reflected by all video evidence, he did not say to you at any point prior to you joining, Paul, I command you to help me remove this individual. Paul, I need your help. Paul, help me. Anything of that nature, correct?
I don't recall it entirely.
Would you agree that video evidence is probably the best assessment of that as opposed to memory?
I would say it's valuable.
Let's go to Sarah Forster. Your testimony was, again, your assumption was that you needed to take some action with some individuals based on something. But no clear, no specific direction, no command from Sheriff Norris with regard to Sarah Forster to remove her from the building.
There's no assumptions. It was based on what was happening in the event.
But not based on a direct command from Sheriff Norris.
Sheriff Norris was giving me directions all day long in that event. So
I'm not asking about all day long,
Okay.
sir. And I'm just trying to be very specific.
I was told to clear the hallway and maintain order in the hallway by Sheriff Norris.
You agree, the videos reflect that Sheriff Norris was nowhere nearby when you had your interaction with Sarah Forster, wouldn't you?
I would agree that he's not in there, but he had already given me that direction earlier.
Early.
Yeah, before, yes.
So, at some point prior, your testimony, you're asserting that the sheriff, some point, unknown, is not captured on any piece of video evidence that's been admitted, not testified to by any other witness in this case, which I believe is that
Argumentative and this states the evidence. Sheriff Norris already testified to that fact.
But with regard to Ms. Forster specifically, the sheriff never commanded you to do anything, correct?
I believe I was helping assist him.
With Sarah Forster specifically, sir.
Everything in the
Focusing
hallway.
on your interaction with her. The sheriff never said remove her, did he?
Didn't need that. I heard that directly.
No, that's, we'll let that answer stay.
I should rephrase that. I didn't need it at that time, space continuum.
No, it's your
At that very
assumption,
moment.
right?
Not my assumption.
So your belief is that based on some vague assertion, based on your testimony, Deputy Sheriff, was you clear the hall. That justified what was depicted, the actions that you took, as depicted on the video evidence is better.
Absolutely.
You didn't clear or attempt to clear anyone else from that hallway, did you?
I did, yes. Multiple
So
people.
when the jury rewatches that, what point?
Well, these videos are very distant. They're hard to see the minutia of it. And so there was multiple times in that hallway where I attempted to clear multiple people in that hallway.
You were here and watched the Jesse Jones cell phone video that was admitted, I believe, it was 67, I want to say?
7?
Was, in which that contains Sheriff Norris recording that he made on Mr. Jones' cell phone, including the moments when you went out into the hallway with him. And in your testimony on direct was that you effected detainment by Sheriff Norris's command. Viewing that video, you'd agree, wouldn't you, that the first person to mention any form of restraints during that video was you?
Absolutely.
And that you volunteered to use flex cuffs, zip cuffs? You suggested that.
I suggested that at that moment, I was concerned that we didn't have a way to restrain him based on my experience and my training and with the events that were transpiring in the hallway. So that's why I asked the sheriff specifically if he wanted me to use the ones that I could provide, because he said he didn't have any.
You asked him, you have handcuffs, I have zip cuffs, correct?
Yes, something to that effect, yeah.
And he said, no, I don't have handcuffs.
Yeah.
And you said, oh, so effectively, I'll get zip cuffs.
I said that I had some, I just needed to acquire those from one of the guys that was carrying those.
You agree that at no point during the exchange you just recounted or what was recounted on that video did the sheriff say, you must detain him, you must put him in zip cuffs, you must put him in handcuffs or restraints?
I think the language speaks for itself on the video.
I would agree. You haven't attended Idaho Post Academy, have you?
No,
You understand that's a peace officer standard?
I do.
You made it clear to Sheriff Norris that you were not post certified.
I have no certificates.
What's his name?
Your understanding, Sheriff, well, let me ask you this. You agree when Sheriff Norris was at this event, he was not on duty?
Objection.
I'll clarify. By on duty, I mean he was not operating business hours?
My understanding of the code of the sheriff is that he's on duty 24 hours a day.
That's your understanding? or
That's
assumption?
my understanding, yeah, according to the Idaho 313302.
And you were not present during the sheriff's initial interaction with Teresa Bornpole, correct?
I was not, say that again?
You were not present during the sheriff's initial interaction with Teresa Bornpole, correct? You were here
I watched so
while
many videos. I don't believe the initial contact
That you were not.
I don't
present.
recall. I don't recall.
And you were not present as reflected in the videos when he made any comments whatsoever to the other individuals.
I was fluidly moving about the auditorium and the hallway, so I was in and out of those rooms constantly, but, so, don't recall.
But you did come in some point after, grab Teresa, help Jesse Jones and Christopher Berg pull her into the aisle, correct?
I didn't get that far. I had hold of her, one of her legs, ankles at one point briefly, and then I backed off because of the other incident.
And that was when you went and joined, helping
Correct.
with her, or with, Victor Jones. You agree that, as far as any video evidence, and I don't think your testimony in direct is to this effect either, that the Sheriff Norris told you at any, or Sheriff Norris told you, command, at any point to, personally or having subordinates refuse to answer any questions if they were within somebody?
Objection, no.
Can you ask a question?
You weren't commanded to refuse to answer any questions or identify yourself, were you?
Can I refuse to identify myself? I just don't. We can ask it in different ways.
Sure. You were commanded, Sheriff Norris, to refuse someone's request to identify yourself.
Oh,
were you?
no, not at all.
To refuse to answer any questions they might have with regard to your authority.
Yeah, I mean, that wasn't an issue.
You were never specifically told, directed by Sheriff Norris that any of the individuals that you engaged physically with were under arrest, correct?
I took his lead on all of that.
But he never articulated those words, did he?
You'd have to ask the sheriff.
You were here to testify.
Yep.
You never said
Any
anything.
argument is
Sustained.
But your recollection of the sheriff's testimony, would you agree that he did not say at any point that he
objection, asked and answered.
Well, I don't think the testimony is completed either. It's an improper question, objection sustained.
at no point based on the testimony that you've heard thus far, the evidence that's been admitted into evidence thus far, were you told that any person was under arrest, right?
It was,
Objection, asked and answered.
yeah.
Oh, what would the answer?
It was implied by the nature of the sheriff's doing his duty and trying to continue to keep the peace in that, and it was exigent.
So well, you've been very patient.
Oh, thank
So,
you.
so I think we got, in your security grants, going back to that. Page 5, their policies, you agree that one of the identified their policies is de-escalation tactics, correct?
Correct.
Would you agree that in this,
Which bullet point are we on?
that's page 5, and so it's under the heading of their policies, at the bottom of that page, and it's the second to last.
Okay.
Third,
Yes.
de-escalation tactics. You agree that benefit of hindsight, a better de-escalation tactic in this case might have been to simply pause the meeting before any hands-on acts are taken.
I don't,
There's no foundation for this witness to have been able to pause the meeting.
I'm not asking.
I think the question relates to a de-escalation technique that this witness has testified to, and so we overrule that objection.
You agree that being effective, right?
I agree in the process of de-escalation, yes.
You agree that as far as the meeting itself, the entire meeting, actions that happen after that may be a better, call it a de-escalation tactic, but the tactic overall might have been to ask people to leave out the non-public interest. Do you agree with that?
If that was in our immediate, our immediate incident area, absolutely, but that was not always afforded us. So,
Knowing what's shown on the videos, you agree there's two exits, the back exits to the audience. Would you agree that the nearest exit at the time the incident was traceable was taking place? You're facing those exits, the one to the right is closer.
depends on where you're at in the room and what's going on in the room.
But where Trouette, where she was seated, that would have been more direct exit, correct?
Potentially, yeah. I mean, it just depends on where you're placed and where you're seated. If you're inside an area that you're not able to, get out of that access.
And I get that. Somebody on the opposite side, like Ben Stallings, it wouldn't have made any sense to direct him to that opposite exit. Do you agree with that?
Yes.
And that was also the non-public entrance. That wasn't being used as an entrance during the
No, correct.
So these concerns about clearing a hallway or avoiding interference by other individuals, that might have been more appropriately met by going over there.
Well, we did ask those individuals that were in that aisle. There was
Well, not asking about what you asked.
Okay.
I don't want to get into.
I'll give you an example of the dynamic of having them move out of that way in that aisle. They have an option to do that, and they chose not to. We didn't afford that to them.
Well, I appreciate your patience with me. I have no further questions.
Thank you.
Mr. Mayor,
Nothing further questions.
thank you, sir. You may return, counsel.
Thank you.
Oh, you know what, I think you have some exhibits.
Oh, yes.
Give my
I'll
10
give this
minutes.
to you.